think that's what you said, 21
Garage is
feet?
gonna be 21 feet high.
Yes.
And then clarification on the addition, it was said, he said it was going to be 27 feet above the first floor level. I don't understand what what does that mean? How high does that mean it's gonna be? Is it from 0 to 27? Is it from where they're gonna do some anchoring? I don't understand where the 27 would come on the addition that they're talking about.
Okay. Is that?
I'm confused, I'm sorry.
Not a problem. I don't want to cut you off.
Sure.
I want you to be able to ask whatever questions and make whatever comments you'd like.
Yeah,
And then we can invite the applicant back up to clarify that
okay,
particular point.
that'd be great. Okay, thank you. So those are the only two things that we really can discuss, right? The right-of-way is not up for discussion, or me reading a statement to you guys? Because
You're
it's-
welcome to make whatever statement you want to address your concerns with respect to
Those
a
two things. Okay.
They've just now addressed the legal issues. You're allowed to respond on that.
Okay, so because what I was going to address was the whole project that they were talking about, with the lagoons and the
So
runoffs and everything, so obviously that's not pertinent.
For everybody else who came here to address larger issues with respect to the overall project, what the ZBA chairman was referencing with respect to the two particular variances that the applicant is now seeking, the rationale is the applicant did a very detailed scope of, site plan and, scope of work, presented that to the planning board, which is their first step. And then the planning board referred them to the zoning board of appeals to see what variances may or may not be granted before the planning board does further detailed analysis about the layout, how everything's going to be situated, what changes are going to be made throughout the entire site plan that don't require variances. They didn't want to go through the process and have everybody here going to the planning board for multiple meetings, potentially for months on end, to look at how it was going to be laid out, not knowing whether or not this board would grant the variances that the applicant was seeking. And that's why they referred the applicant to the zoning board of appeals first, to see what variances the zoning board would be willing to grant, and then they will be referred back to the planning board for further analysis of the precise location and so forth that do not require the ZBA to grant any variances. So any of those other issues with respect to the layout of the site, entry, exit, what's going to happen as far as traffic on the street and so forth, all of that, everybody will have an opportunity to address at the planning board once this board is done with whatever determination they make.
Okay, one last question for you. The issue of the right-of-way, that's not for you guys to discuss or talk about, or is that something that is legit?
So the right-of-way is a legitimate concern
Okay.
you might have.
I'm going to tell you why my legitimate concern is, more than anything, okay? It's because there are three of us on that ledge, okay? It's Tom, and Castleman, my house, Phil that spoke last time, and Bruce that's back there. One of our biggest concerns when I saw this was emergencies. Fire trucks, ambulances. The corner is tight. We get trucks down there for deliveries and everything else like that. Now that he's not going to do the caretaker house, obviously that driveway is not going to be any damage done to it. But my question is, with a right-of-way, if, God forbid, an emergency happens, that we can get an ambulance down there or a fire truck, even though there's a fire hydrant right at the end of the driveway, it would be much more convenient, and they would be able to do that. I don't know the size of the trucks. I don't have any idea. Mike is the assistant captain for the EMT, so he would know more about that than I would. But that's really one of my main concerns. Did I know the right-of-way was there? We all had an idea. The fence was there, yeah, because the Jeters just said, listen, we're not gonna do anything here, we're just gonna live here, which was great. Everybody gave them their privacy, they gave us our privacy, and if we needed to do something with the Jeters, they already told me, if you need something, just let us know. Just like I said to them, if you ever need help, let me know. Those are my concerns, those are our concerns, is not the right-of-way. I don't wanna, drive through the middle of his property because I can drive through, why would I do that? Okay, I don't think any of us would want to do that. But my concern mainly is, how do I get an emergency vehicle down there? I can't even get furniture deliveries down my driveway. Not saying I would ever do that on the right-of-way, but that right-of-way was put there for a reason. And that right-of-way was there when the property was, sorry, John? Yes, John. I'm sorry, John. Can I say John? Okay. When, as John said, they did it way back when, okay? That was why there was no other way in. They used to come in, turn around, and go the other way. Now, you could ask me, why can't we go out the other side? Well, they lost that case. There's a tree there now. So, can't go out the other way like they used to be able to. So the only way for the access to our houses is down my driveway, which is on my property, okay? This right-of-way now says, whoa, if there's an emergency, God forbid, I can get a fire truck down there. I can get an ambulance down there, okay? There's a section of fence there, yeah, covers the road. We were both happy with it. As a matter of fact, the Jeters, when I asked them, they were gonna put the slate wall right across, and I said, would you mind not doing that? And they said, yeah, not a problem. That's how we just were cooperative, okay? So that's my point about the right-of-way. That's really a major concern of ours. I mean, I know they've conceded a lot of other things, but the setback is the code. The right-of-way is really important. I mean, I didn't realize how important it was until when I found it. I said, ooh, this is, thank heavens, now I don't have to worry. We can get somebody down there, okay? And as far as the garage is concerned, if the code says it's 7.2 and it's 7.2, have at it. There's nothing I can say about it. I'm not arguing that, okay? But the setback's supposed to be 18, then make it 18. The right-of-way is important for the reasons that I just stated. That's really important to us. So, from those two aspects, that's all I have to say. Thank you.
Thank you. Anyone else from the public?
Before we raise additional points, as I mentioned to Mr. Savino, I wanted to give the applicant an opportunity to address his expressed concern.
Okay, when it comes to the height, when you see the addition, the property slopes down a little bit. So I didn't want to say it's going to be 25 feet here, 27 feet here, and 31 feet here, because depending upon where you measure from where the addition's going up. So what I did is I just took a straight line from where the first floor, so when you walk up to that property, there's 2 steps to get to the first floor. From that first floor where you're standing, it's gonna be 27 feet, under 27 feet from that point. That's what it means. So by the lake, it might be less than 27 feet. Down towards where the driveway and the gravel is, it will be, the foundation will be more, because we're no longer digging a foundation. We're just gonna pin the foundation into the existing rock. So this way you only have to drill 5/8 holes. There's no hammering, there's nothing else. We just pin the foundation. When we pin the foundation might go down a couple of, will be a couple more feet below that first floor level. Might be 2 feet, might be a foot, might be 3 or 4 feet. That's why I just said 27 feet above the first floor. Hopefully that explains it.
So I think the point that needs to be addressed, if you look at the bulk table on the screen, it identifies that the required building height is not to exceed 35 feet for a residential dwelling. And on the bulk table, it says existing height is what's proposed. Existing height is pre-existing, and what's proposed is less than the existing or greater than the existing?
It's gonna be, it will not be close to 35 feet. Won't even be close. Why that's existing is the towers 65 feet, 70 feet high.
Okay.
So that's why. Okay. Does that help?
I,
No. Okay.
I think that answered my question. Hopefully it answered the question for your neighbor there.
And I'll just take it a little bit further. The, on that height, on the 27 feet, usually, the ground around a house is not level. Usually what end up happening is they'll take an average height and then measure from that distance. So they're not taking it from the lowest point and going up the 27 feet. You could technically have a house that actually sits 35 feet or a little bit above, because it might have a walkout basement on one side, but on the other side, it's 2 feet. So they usually take an average for that. So again, there is not a variance that's requested. 35 feet is the code. They're well under that. So hopefully that answers some questions on that height. Okay.
Kathy Buchak, I'm at the other end of Arion Court from
Sorry, can you spell your name, please?
B-U-C-H-A-K.
When you say the other end, just,
There's, Arion Court used to go all the way through. One of our neighbors petitioned the town of Warwick to close it because he owned property on both sides. And my grandparents bought the property that we own now in 1947. And there used to be, we used to go all the way to the castle, we used to go around the road, through Arion Court, up through past the castle to enter and exit. And one of the neighbors, 2 houses from the property, petitioned the town to close it so he could put his septic system in the road. So the right-of-ways are very important to the neighbors and the neighborhood in the way they exist. And the fact that that was closed some 15 years ago between both ends creates a problem. We still have problems with delivery trucks going down the road on the end that Mr. Savino lives on and not being able to turn around and get out. So the rights of way and the width of this road and the roads on Lakeshore Road, it's a problem. To get at the other end of Lakeshore Road, there's a telephone pole. When you come into Lakeshore Road, there's a telephone pole, and for trucks to go around it, it's a very difficult maneuver. So to have, if for any reason they needed to close for construction that end of Lakeshore Road, that would be difficult. There is nowhere on Lakeshore Road for a vehicle to turn around. It's in and out. So a fire truck, to have them back up to get past that telephone pole and around the stone wall at the other end of Lakeshore Road would be impossible. For a delivery truck with a tandem trailer or something like that to come down and to maneuver, they have to be able to get out the other side. But most importantly, I understand their concern about the right-of-way because ours was taken away. And unfortunately, I wasn't involved in that process. I was away at school, and I didn't know it was happening. And my family fought it, and still, the judge that they brought it in front of permitted the closing of the road. So the road is now divided in half, and the right-of-way was taken away from us. And I don't think that was right, and I don't think going forward that, you know, that should just be taken as a, oh, well, that was years ago. They were put in place for a reason, and whether or not you mark this boundary or that boundary, it was used, it's still used, and it should still exist.
Thank you.
So, Mr. Savino also raised the issue of the right-of-way, and now we have a second neighbor who has raised an issue about it, and I just wanted to try to summarize for the benefit of the members of the public here, as well as the board. The attorney's applicant, Mr. Ziobro, had summarized earlier the fact that the applicant had done a search, a title abstract, going back decades and decades and decades, all the way back to the 1920s. My recollection, it was like a 106-page long abstract of old deeds and so forth, along with a legal summary. I identifying as far back as they can really kind of look to ascertain whether or not the right-of-way that is referenced in Mr. Savino's deed that he raised as an issue is clearly ascertainable, whether or not it's clearly defined in any of the recorded public records. And based on that abstract and my review of the summary that Mr. Ziobro put together, it's my opinion that I agree with Mr. Ziobro from a legal perspective that the right-of-way is what's called undefined. It isn't clearly demarcated by metes and bounds. It doesn't identify specific identifiable locations. It merely states in general terms in several circumstances that it's a right-of-way for the adjoining owners, among others, along Lakeshore Road to have access over the property of the applicant to access the public road. Mr. Ziobro just presented earlier that he believes that what it may be in fact referencing is exactly the same point that the ZBA chairman raised earlier, and that is the fact that if you look at the chart over here at the site plan, this dark black line is the property line for the larger parcel, and it runs right down the center of Lakeshore Road. As I zoom out a little bit, you can see that this is one big parcel here, and it crosses over Lakeshore Road all the way up and around. It's a single tax lot that actually straddles over Lakeshore Road, and it's the applicant's position, as stated by their counsel just a little while ago, that the right-of-way referenced in Mr. Savino's deed and possibly several others, there were they specifically looked at 3 different parcels in immediate proximity to this parcel, and all the deeds referencing that all the way back over 100 years. And all of them make a general reference of right-of-way over the Goodwill property, which is the former owner of this parcel, is my understanding, to the public road. Now, this has always been the old public road. And so going back that far, Lakeshore Road would not have been a public road 100 years ago, but this was. And so while this board, and me personally, nor does this board have the legal capacity to declare whether or not this easement is limited to what we're suggesting we believe it might be. Anybody who feels that they're aggrieved could take whatever course of action they would like to in the courts to see if they can try to prove that the easement is something other than what's being presented. But from my reading of the title abstract and the summary of the applicant's attorney, I think it's a fair assessment of what it probably is. We're not making any judicial declarations. We don't have the ability to do that. We're not declaring that that's what it is or what it isn't, but it's a rational basis. And we don't see any other, or I didn't see any other specific details in that title abstract that would identify the specific location of the easement to suggest that it actually would, in fact, cross over through the driveways of this part of the property. It wasn't that specific, and I looked for it specifically to see if I could find anything that would have suggested that it meant accessing the driveways of this property. I could not find that myself. I'm not saying that somebody else couldn't if they dug deeper, but the applicant's counsel also pointed out, even if that easement did provide a right-of-way through the driveway of this parcel to the adjoining lot where Mr. Savino lives and owns that property, that the specific variances and proposed improvements that the applicant is creating would not preclude that access if the neighbor was capable of proving that they had an actual right-of-way. I'm not even going to get into the claim of potential adverse possession and whether or not having a fence along this boundary would cut off that access in perpetuity. That's an issue for the courts, not for me, not for this board. The applicant's counsel already stated that, it could be, it may not be. That's a legal judicial interpretation that would have to be made if in fact any of the applicant's neighbors wish to pursue that. But I don't see any basis to preclude the granting of the variances solely based on the fact that there's an old reference to a right-of-way to the public road from the neighbor's adjoining property that doesn't otherwise specifically specify that it crosses over this particular section of the adjoining property, when we know for a fact that Mr. Savino would have had a right-of-way along Lakeshore Road across his neighbor's property here to the public road, which is State Route 210. Any questions from the board members on those legal issues? That's what I'm here for.
I agree with what you said.
I'm sorry, go ahead, Aaron.
I agree, tend to agree with Jeremy said. That's my interpretation, was that Lakeshore Road, being as everybody knows, and I know how narrow that road is, I would tend to believe that's what their definition of the right-of-way is. But that's for a court.
I don't know if it's not on that particular easement. It's another question that I have.
Sure.
Okay. I had asked this once before. You have lot 1. You're coming in from from Lakeshore Road, coming across lot 2 to get to lot 1. Since it's 2 pieces of property, if one piece is sold, how do you get to the second piece of property?
We will make sure that we will have an easement between Lot 1 and Lot 2, which has a meets and bounds description. And we can make it subject to approval, either here or at the planning board, that we would have an easement between Lot 1 and Lot 2, that they can go over the lands of each other for ingress and egress. And anybody, and any good attorney, let's say we were gonna sell Lot 1, which is not in our plans at all, any competent real estate attorney in the area would know that they would need that as well. I mean, I'm just saying that would be something title insurance would also review. Title insurance is always guarantee access to the public roadway. So if they didn't see that in a title report, they would raise that as an objection to the sale, and then the attorneys would work that. But we won't have that mess, because I will make sure that I will draw up an easement agreement, either reviewed by Mr. Havens and or Mr. Krahulik, saying that Lot 1 can travel over Lot 2 to get to the public roadway. And that would actually make the property valueless, and that's the last thing. If we're selling it, we would not want the property to be valueless. You can't have a landlocked property. They would actually have an easement by prescription, which means by necessity. Let's say we all dropped the ball, everybody, and nobody did an easement, and we sold that lot and somebody bought it. There isn't a court in the world that wouldn't give them an easement over our land to get to a public roadway. You can't make a piece of property an island.
I concur.
Thank you.
Public hearing is still open. Just want to state your name.
Robert Morocco. I live at 135 Lakeshore Road. And my concern is whether or not Lakeshore Road would need to be closed. And what would the detour of the traffic entail? Now, we live on the corner of Ann Court, which is a private road, but it's the only road Lakeshore Road is a jug handle. Okay, so you have the New Jersey side, which is the Lakeside Road side, and you have the Jersey Avenue side. Now, in between, the only piece of road, which is a private road, by the way, is Ann Court. It's only about 8 feet wide, and all it is a glorified easement where 7 houses pull out of their driveway onto Ann Court to either access Lakeshore Road or Jersey Avenue. So if Ann Court is in the plans to detour the traffic, let me state to you right now, it is a bad idea.
Okay, I'm gonna interrupt because it would be in the reference to the two area variances that we're looking at. And I will say that if the road itself, it can't be closed, and this is what I brought up earlier, that the town must have some kind of an arrangement or an agreement with that road because they're doing the maintenance to it. So the applicant can't in any way close the road.
Okay, so when I...
And also, to finish his point, the issue of whether or not the road would be temporarily closed in association with any construction activities, if that's in fact your concern, would be an issue to be addressed at the planning board stage, not here at the ZBA. Here we're looking at the variances from the zoning code that they're asking for. The planning board will address things like staging, timing, the whole construction process and so forth. That would be a question to raise before the planning board as opposed to the zoning board, because they're not going to get approval to do the work that they're planning to do without having to go to this planning board for site plan review. And that's where issues such as, whether or not there's going to be any temporary road closures in association with the proposed construction, those would be addressed there.
Well, detouring the traffic would also come under that? Because the cars would have need somewhere to go.
That's exactly my point. Those
Okay.
would be issues to be presented to the planning board, because this application, unlike some, we had somebody here a month ago, all she wanted to do was put up a fence in the front yard, within the front yard setback. It was a very simple issue. She didn't need to go to the planning board. This is a complex site plan. When we're done here, this application will have to go back to the planning board, and that's the proper board to consider issues such as traffic interference.
All right, thank you.
Thank you. Anyone else would like to come up?
My name's Mike King. I live at 18 Lakeshore Road, right above Dominic and next to Tom. And question I have is regarding the variances for you're gonna have, I think it's 5 bedrooms put onto the castle and 4 bedrooms down in the addition on the Lake House, lot 37?
That's not, we heard of some different things, but that's not before us at all.
No, I understand, but my question is related to the septic plan and how that relates to the variances.
So, to answer that question is, and again, we hate saying this over again, it's a planning board issue.
Okay.
And, what before us, whatever, they're making the expansion in the house, for the number of bedrooms, whatever it is, that all will deal with the planning board.
Okay,
They're only seeking that variance on the side yard setback.
okay, thank you.
And front yard.
And, well, yes. But the front yard one was the garage, which didn't have anything to do with the septic. Okay.
So for the benefit of the rest of the public as well, when the applicant goes before the planning board, as was referenced previously by the applicant, they're going to have to seek Department of Health approval for this septic system. That'll be part of their planning board application. So the Department of Health is going to analyze with their engineers whether and to what extent this septic system is appropriate and it can accommodate the expansion and the number of bedrooms that are being proposed by the applicant. The town engineer, who works hand in hand with the planning board, will also be reviewing those issues at the planning board stage.
Thank you. Anyone else for this application?
Rob Cole, 17 Jersey Avenue. I have a question for you. I'm a little confused. I heard the term Airbnb kicked around a couple of times tonight, and I was under the understanding that you had to be an owner living there 365 days a year, full-time owner of the property, and that had to be your residence or have a B&B. Is that not correct?
Technically, no. There's a couple of different options and alternatives under the recently enacted short-term rental regulations in the town of Warwick, one of which is that the property owner has to reside on the premises, but as an alternative, the property owner has to provide a person who is the designated responsible party who does in fact reside within Orange County, is what the town code requires, so that you don't have somebody who's living out in Suffolk County, for example, owns the property here, and it's going to take them 3 hours to get here.
Right. But wouldn't the
Is the
short-term
rationale
rental,
behind the code.
wouldn't the short-term rental be considered commercial and not residential?
Not under our town code. The fact that it's, the fact that the applicant is planning to rent it out to people on a short-term rental basis does not automatically convert the property to a commercial use, so long as the property was initially a single-family residence, which these properties in fact were. It's one of the reasons we asked the applicant to address the issue of what's the difference between this property that may have 9 bedrooms on the larger principal dwelling, and a country inn. I specifically asked the applicant to address that issue, and their counsel addressed the issue earlier this evening when he first presented by pointing out the distinction being that a country inn, a hotel, a motel, or any other transient type of commercial overnight accommodations would include private use of a particular bedroom, where there's the capacity for different people to independently reserve a different bedroom. In this particular case, they're not going to have separate locks on the bedroom doors. They're not going to be renting it one bedroom at a time. They're going to rent the entire property to one person at a time, and that's what's permissible under the Town of Warwick short-term rental regulations.
Wouldn't the fact that the pool that's there, if it was used by people that rented rooms, turn that into commercial? Because I think the Warwick zoning says that it's for residential use and their guests only, and not commercial use. It specifies that.
So
and that would have to be a separate issue, that it would turn it into a commercial property.
Would the applicant's attorney like to address that issue? I'm sorry, John, 1 second.
Yeah.
Was that your last question? I don't want to interrupt
I think
you.
for tonight. Is there going to be another meeting after this at any time?
That's up to this board. I don't make that decision. That'll be up to this board as to whether or not they're prepared to move forward.
Okay, this discussion, we had workshop. What people may not know is before we bring any application even to the planning board, we meet with the town planner, the architect, the engineer, and the members of the planning board. And that question came up, and me and Mr. Krahulik looked into it. And Airbnb in-ground pools are not considered commercial. Otherwise, there would be no Airbnbs with any pools in Orange County. I even went to the Orange County engineers. I met with them personally and explained to them, because the town planner was on the side of that gentleman at one point. And I clarified, and Mr. Krahulik confirmed, that if it's a residential house that's also used for Airbnb, a pool is not considered commercial. The county doesn't have to get involved. There's no special requirements other than complying with Town of Warwick residential pool laws. It's the same reason why it's not considered a commercial property, because you rent it out as an Airbnb. So just the fact that you have a pool on the property doesn't now change that Airbnb into a commercial use.
And are you done, John?
I'm done unless you have any more questions.
So to address your point, I wanted the applicant's counsel to be able to present his argument first, but I had the same concern that you raised, and I investigated it myself earlier on in this application, and came to the same conclusion that the applicant's counsel did, that the prohibitions on the use of public pools, the allowance, rather, for a residential pool is limited to private single-family dwellings, which is what you have to have in order to qualify for short-term rentals under the short-term rental regulation. And I looked at the code provisions under both the section applicable to residential pools as well as the language in the short-term residential rentals. And I didn't find any conflict that would create an implication that the mere renting out of a private single-family residence on Airbnb would constitute public use, which is what's prohibited under the town code.
Does anybody else wish to come up on the application? Okay, the public hearing is still open, so if something comes up in our discussion, we can entertain it then. The one question I have right now goes back to if there is a variance that is needed for that deck slash addition. And if there in fact is, without knowing that information, I don't want to give a variance question on another one and not know anything on a third variance. So,
I'll make the motion to leave the public hearing open.
Definitely.
I'm just asking the first thing.
yeah,
Mike, can I address that question as to the backyard thing?
sure.
From what I'm seeing, there's gonna be no requirement needed. I'm looking at a drawing that John did. If I need to move the addition back the foot to make that 30-foot requirement, I will make it work. I will not need a variance for the backyard. I'll make sure of that. I just measured it before. It's right, I think, at 30 feet, but if it's not, I'll make it 30 feet.
Oh, I'm sorry. Unfortunately, you're gonna have to come up and state your name so that everybody can hear.
I don't know if this goes before the planning board. My name is Michael Velle. I live at 6 Lake Shore Road. I own the property adjacent to the Tiedemann Castle.
She didn't get your name, I'm sorry.
Michael Velle, V-E-L-E. I just had a question about the basketball court.
That's
Not part of it?
before
Okay,
us.
okay, that's fine. I'll bring it to the planning board.
Okay, thank you.
This is pickleball. It's pickleball. And they got a drill to do to flatten this land. This is a rock ledge right here. There's nothing here now. There is here. It's a septic system. And a little player that they're gonna put a pickleball. Still too much.
I was gonna have you say it.
So, in looking at the initial list of variances that were proposed to be needed for this particular project, I understand that the applicant has done a lot of work revising it to eliminate the vast majority of all of those variances, and previously, they identified earlier tonight that they're only seeking the 2 variances that we've discussed on several occasions. However, under Town of Warwick Code 164-45B1 and 164-41A1A, being that the Lot 1, tax lot number 37, is a pre-existing non-conforming building with a 1-foot setback from the property line adjacent to Greenwood Lake. Any expansion beyond 15% would require its own separate variance, and we would need to know what the actual expansion size is going to be. The applicant just stated that if they need to move the back of the addition on Lot 1, tax lot 37, an extra foot or 2 away from the rear property line in order to avoid the necessity of a rear yard setback, that would modify the square footage calculation for the expansion of the pre-existing non-conforming use, and we would be incapable of calculating that without these measurements. And so the chairman has asked if we should consider holding the public hearing open until we get these final calculations so that the ZBA can consider all of the applicable variances that may need to be granted in a single session.
Yeah, we do not object, and we waive the time requirements to the next meeting. We'll get, again, Mr. McGloin got sick on us, so we got a little confusion with the maps, so that's a little bit on our side. So we can keep this open to the next meeting. Hopefully, we can have all the plans right in time to you, and we can ask for a vote next meeting unless something new pops up. But that's, yeah, unfortunately, with the wrong map, I already knew that this was gonna happen.
Good, we can, and again, on the 30 feet, you can take a look to see, because if there's going to be a variance of a half a foot or a foot, you know, again, you could, if it works that it's 30 feet, great. If not, if it's something that's minor, that's fine too. So everybody understands that we're gonna hold it over, because on this third one, we really need to know some numbers first. So unless anybody else has
I'll
any
make that
questions.
motion to leave the public hearing open and continue at the next meeting.
We have a motion and a second? All in favor?
Aye.
Aye.
Opposed? Okay.
When's the next meeting, folks?
Going to tell you in a second. What? Wait a minute.
So I can answer and say the 4th Monday of the month, but that doesn't help you,
I'm going to tell you in a
July
second.
22nd.
which is the 4th Monday of the month.
And that will be at 7 p.m., and we will make sure that we have the doors open this time.
And technical difficulties taken care of.
I just get back from my cruise. Going to Nova Scotia.
Thank you.
Never been there. Oh, yeah.
Thank you for your time, folks. We appreciate it.
Thank you. Again, out of order, the third item on the agenda for continued public hearing of Jason and Gina Valaquette. You were, oh, back there, okay. You're gonna pull up this map?
Yeah.
Okay.
Good evening, everyone.
So the public hearing is still open on this. I had a couple of questions after reviewing. I just wondered, before I get started, was there anybody else, any questions or concerns? He's gonna pull up the map, of the property itself. I went to the, building department and I looked at, maps and I looked at the, aerial photos that they have from year to year to year. So it just, after looking at the property, what, the one of the,
Survey?
survey, thank you. So we see that the one shed is going to be removed, and then the other shed, we were talking about moving that one back further. When you look at a picture, as opposed to the survey itself, you know, the entire area over there is gravelled as if you've been using your neighbor's property for a very long time, and the survey does show that. I personally am not in favor, and again, I'm not talking about the shed that's kind of not on your property, the one that is on your property, is moving that shed to the front of your house where you have room to put it and not need any variances. So I say that, but the dilemma is you can't move it unless you go on your neighbor's property.
My understanding of, to move it would be to push it back this way.
I understand, and that's what we had talked about, but you still need variances in order.
Correct.
And our board, if there's a way of not giving a variance and making the situation work, it's a reason to deny the variance in moving the shed. So with that, I was gonna ask the attorney just to speak on the, I guess, on legalities of moving a shed and onto or across a neighbor's property.
All right, so in reviewing this more closely since the last meeting, the applicant had submitted a few easement agreements. He submitted a survey that identifies all of the neighbors, and the survey identifies several maps for the adjoining properties. I took a closer look at the adjoining properties and also the deed references. If you'll notice that there's a deed reference over here for Offenbach. There's another one for Johnson, who owns this parcel where the little small shed is encroaching onto her property, and a significant portion of the gravel driveway is encroaching onto the Johnson property as well. I did want to identify for the benefit of the public as well as the board who may have missed it. Late this afternoon, we received an additional objection letter from the owner of the Johnson property. Sorry?
Letter of no objection.
No, we received an additional letter of objection from the owner of the Johnson property. Who this small 10 by 10 shed is encroaching on, specifically reiterating, she explained that she would not be capable of attending tonight, but she wanted to reiterate her objection to the granting of any variance or the use or encroachment of any of her family's property. So she did specifically submit that letter late this afternoon. I wanted to make sure the board was aware of that. I did forward it to everybody, but it was, I think, after 4 o'clock this afternoon. So it might have been 4:30 this afternoon, so they may not have seen it. That being said, I did check. There's the same filed map reference for all of the surrounding properties. It's filed map number 1011 and 708. If you look at the deed references on the survey, it also identifies map number 708 from 1930, map number 1011 from 1933. I'm sorry, excuse me, could you guys please, thank you.
It's not us talking, it's just outside.
Oh, thank you,
Yeah.
Yes.
thank you.
They were quiet.
Sorry about that. I just heard it coming from that direction.
Yeah, I didn't want you to think it was us, but
Thank you. So I went ahead and pulled these maps, and this is the map from 1930, map number 708, creating the original subdivision of the applicant's parcels. In his deed, it references tax lot, subdivision lots number 125, 126, and 127. I've highlighted those here in red. That's the principal part of the applicant's property. The adjoining parcel that's highlighted in green here, that's identified as lot 124, and the adjacent parcel across the street, lot number 103, these are the properties that are owned by Johnson, who is objecting to the granting of the area variances, and this is the parcel where that 10 by 10 shed is encroaching. If we look at the 1933 map number 1011, and you look in this same area here, you can see, and in the applicant's deed, and I can show you, I can assure you, if anybody wants to see it, I have pulled the deeds from the county clerk's office to look at the deed descriptions. But this lot here is a little micro lot, numbered lot number 74 on this subdivision from 1933. This tiny triangular landlocked parcel that has no adjacent public road to it is the odd-shaped corner on this survey over here where the applicant's large 12 by 20 shed is. This is that separate lot 74. And if we go back to the deed in 1969, which is how far back I went looking in the deed records, it has the exact same references that the applicant's deed has with respect to the legal description of the property being lots 125, 126, and 127 as shown on the revised map of Greenwood Lake Terrace, made in 1930, filed in the county clerk's office as, filed in the Orange County Clerk's office. And also lot number 74 as shown on the map of Indian Park dated 1933. And so those are the two maps that are referenced in all of the deeds going back into the 1960s. It's been the same parcel that has been conveyed over and over. It's not like this parcel was sold separately 10 years ago or something. So this lot 74 has been part of the consistent deed title to every owner since the 1960s in association with the lot 125, 126, and 127 that make up the majority of this particular applicant's property. And so where the survey shows that there's actually a slight break and opening in between and connecting this part, the main part of the parcel, to this triangular section, in reality, that survey must be based on an imperfect meets and bounds description from who knows how many decades ago, when they were using less sophisticated technology and so forth. And if you take this line here, which is identified on this particular survey as 28.52 feet, and you compare it to a prior deed reference, I'm sorry, not the prior deed reference, but the actual subdivision map from 1933, that specifically says that this is 31.8 feet. It's 20 feet from the middle to this side, but on the subdivision map it says it's 31.8 feet. So at some point there was a little discrepancy between 31.8 feet and 28 feet. In any event, it's still the same parcel, and if you were to extend this 28.5 foot line to its continuous extension, it would probably be around 31 feet and close off that triangle. What's the relevance? This particular section of the property, because it is landlocked, is entitled to an easement by necessity. So the law says, as the applicant's attorney said in the last application with respect to the property closer to Greenwood Lake, if a particular tax lot or a section of property is inaccessible in its entirety from a public roadway, then an easement by necessity automatically rises because you can't have property that's inaccessible. The law does not permit property to be completely inaccessible from a public roadway. So even if there isn't a legal granted right of way to the public roadway that's recorded, then in that circumstance an easement by necessity would be granted. I provided, for the benefit of the ZBA members, some legal references with respect to an easement by necessity, and specifically referencing an appellate division case in 1996 called Stock versus Ostrander. And in that particular case, the court held that to establish an easement by necessity, plaintiffs must show one thing. The first, that there was a unity and subsequent separation of title between the parcels, and two, that at the time of severance, an easement over defendant's property was absolutely necessary. And it also says, it also finds, in determining the extent of the plaintiff's easement, it is to be assumed that the original parties who created the easement anticipated such uses as might reasonably be required by a normal development of the dominant tenement. The construction of a new home is certainly within the normal development of plaintiff's land. The dominant tenement is the property that is benefited by the easement, not the one that is burdened by the easement. So the applicant's property would be benefited by the easement by necessity, so that he can reasonably access and use his additional parcel that would otherwise be landlocked. And Ms. Johnson's property, who is objecting to the granting of any variance on this little triangular section of the applicant's property, would be the burdened parcel by this easement by necessity. And so while I acknowledge the applicant's neighbor's objection to the granting or use of this area, it's my interpretation, looking at the case law that's applicable, that this is a case where if the applicant is not granted access, they would be deprived of their use of this portion of property, which is recognized on a filed map in the Orange County Clerk's office as a separate lot. And so therefore, as a separate lot that's identified on a filed map in the Orange County Clerk's office, the applicant has the right to access this property, whether his neighbor likes it or not. He would have an easement by necessity. That's my legal interpretation. That does not mean that this board has the authority to grant him any specific easements over his neighbor's property. I'm simply stating that from a legal perspective, he has a right to an easement, but we are not a court, and we do not have the authority to grant any specific easement of a particular size, okay? All I can tell you is it's my legal interpretation of the applicable court cases that an easement by necessity would necessarily have to exist under these circumstances because there's no other way to access or use that portion of your parcel. In the 1996 appellate division case on this point, Stott versus Ostrander, I provided an overview of that case, and it states, the court first determined that the right-of-way easement was absolutely necessary. The court reasoned that the landowners had established a unity of title and a subsequent separation of title because there was sufficient proof that they and their adjoining landowners could trace their title through maps and abstract of title to a common grantor. That we have here in the initial Indian Park subdivision. We have a subdivision map in 1930 and another subdivision map that was an additional portion of the same development, being Indian Park by the same developers, where we had a unity of title and a series of subdivisions that were all done at about the same time, and subsequently they were conveyed, creating a singular lot from 4 separate lots that were previously subdivided. And that lot seems to go back at least to the 1960s. So in its entirety. Further, as an overview in this case, further, the landowners presented sufficient evidence in this particular case, not in the applicant specifically, but in this case, that upon severance, their parcel became landlocked by other properties with no access to a public highway except via the dirt road across the adjoining landowner's property. However, the trial court erred in this particular case back in 1996. The appellate division found that the trial court erred in limiting the width of the easement to 10 feet because under the Woodstock, New York local law number 1 that was applicable, the town code, that town code set the minimum width of a driveway for a single residence at 12 feet. So once again, I'm simply reciting a court case of very similar facts and circumstances. We are not a court. We do not have any discretion to grant any specific easement of a particular size or dimension. If you wish, you may or may not be successful in obtaining a judicial declaration if that's what you need to do to grant that. I can't tell you whether or not that will in fact happen. That's not my prerogative. It's not the power of this board. I want to make that clear. What I can say is, based on the legal analysis, I also want to recite one other section of the legal analysis that I provided for the benefit of the board, and that's the adjacent property owner's rights. New York law recognizes the need to balance competing interests of adjacent property owners. Courts must apply a standard of reasonableness when addressing conflicts between neighboring property owners. That applies to the zoning board as well. The zoning board has a statutory set of 5 statutory criteria, and they have to enter into a balancing, they have to balance the interests under those 5 different statutory criteria of the applicant as well as their neighbors. The legal framework requires balancing the competing interests of the parties and should grant relief when necessary under reasonable conditions and where the inconvenience to the adjacent property owners is outweighed by the hardship of their neighbors if relief is refused. That's specifically citing Supreme Court case in the second department, matter of Rosemud Development LLC v. South. And I just wanted to point out that when the ZBA is considering granting of variances, they do have to engage in a balancing test among the 5 statutory criteria, considering the benefit to the applicant as opposed to the detriment to any adjoining neighbors. In this particular case, the applicant has pointed out previously that the topography of his driveway is exceptionally steep, that the section in question that the neighbor, Ms. Johnson, is complaining about is all the way at the top of a hill, and it's otherwise an undeveloped parcel. It's essentially inaccessible from that parcel because of the topography, and therefore this board would have to make a determination and weigh those factors in its consideration of the applicant's request for a variance. So, questions?
No, that was quite a bit. I'm hoping that this is recorded so that I have the minutes and all that, but I don't think I have any real questions. Well, one would be...
Just step,
sorry.
so you're talking in the
Yeah,
mic.
my
so
apologies.
the TV can hear you.
Did you receive the letter of no objection from Offenbach?
Yes.
Because that was also sent about 4:30. I just wanted to make sure that there was 2 separate things.
Yes, sorry, I omitted that. We did also receive a letter of no objection, and that was from the neighbor over here, Offenbach. The ZBA did receive, again, after 4 p.m., a letter of no objection from this particular neighbor stating that she had no objection to the granting of whatever variances, but she was not specifically granting any easements on that would, authorize any encroachments on her property, but it specified very clearly that she had no objection to the granting of whatever variance was necessary so long as the shed stayed on the applicant's property. Is that a fair summary?
That's correct, yes.
With respect to the easements, the applicant submitted 2 easements, and those easements were from proposed easements. They're not signed, and they shouldn't be yet. The proposed easements are from the neighbors to the north, now or formerly Barry, at tax lot 72-9-24, and I believe it's supposed to be now or formerly Gilbert, as identified on this particular survey, which is dated October 27, 2025. And on the survey, it's identified as tax lot number 72-9-3, now or formerly Gilbert. I reviewed the county clerk public record as far as the tax map information, and that particular parcel is still listed as being owned by Gilbert, but the applicant has identified somebody else as the potential owner. I don't know if maybe the county clerk records are not updated yet.
I believe Gilbert is her deceased husband's name. She goes by Ricky Kipple, and so she's now the owner of that property.
Okay. I didn't dig that far. If you can provide that information for final review.
Yeah, sorry.
Prior to approving the easement, simply because the name that you have on the draft easement does not match what the county clerk records say is the
Gotcha.
owner, and so that was just a red flag that I needed to identify and address. Further, in reviewing the draft easement agreements, I noted that there was a few items of conflicting language within the documents themselves. Give me 1 second. Come on. Let's try this one first. Let's do it the simple way. Before I finish closing these subdivision maps, does anybody have any questions here on the board with respect to those two subdivision maps from 1930 and 33?
Yes.
Yes.
So, pretty sure the shed garage, whatever you want to call it, on that piece of property exists by itself as an accessory structure. An accessory to what? Therefore, it cannot exist. It's a separate lot.
No, it isn't. It's not a separate tax lot.
So,
So under this particular deed, as is the case with many, many deeds in Greenwood Lake, they did these old subdivisions.
yes.
With tiny little micro lots like they were building in New York City
Yes.
with 20 feet wide lots.
So, I am agreeing with you 100%. We were looking at that one, if it's one tax lot now, no problem. But that person has access to that piece of property doesn't mean that they can put a shed there. That has to meet side yard setbacks.
I'm
for
not saying
example.
they absolutely have that right. That's
It's-
for this board to determine.
Yep, and I'm asking the rest of the board, I mean, the way that I interpreted what you had said was that we're looking at this lot as we need a right-of-way to get to it because it has no frontage on a road.
Correct.
The map that we have showed that there's about 3 feet of property that they can walk from that to go to the other piece of property. So I think because they can access the property without a right-of-way.
It's not a right-of-way, I was referencing an easement, but yes.
An easement.
Yes, correct.
Okay, because they can get to it without an easement, I don't think the other holds.
Okay.
So does the other, if we were following what he said, what I said, does anybody understand, agree on the garage shed being there? I'm saying it doesn't have to be there. The variances are substantial.
Looking at the width of that piece, that entrance into there, even though it's one piece of property,
Yes.
you can't get a car in there.
No.
You cannot get a trailer in there to do anything with the shed
Right.
unless he crosses other property,
Right.
of which he doesn't have an easement to do that.
And I completely understand what Jeremy is saying. But in this particular case, this is not a landlocked piece of property.
Not anymore, if it's one piece.
If I understand, this is one tax map now?
It is one tax lot and
So
all
then,
four.
so then that would be
Yeah.
considered an accessory building, Mark?
Yes.
Because if it's
Yes,
one,
because
so,
it's one tax lot.
Yes.
so then that's okay.
I
And-
was looking at it as the way he was describing it as as one tax lot, and at that time, an easement, could be given to that lot. Now, there is a way to get to that lot without an easement. And we also don't have an easement. There isn't anything written, even verbal on that. And again, there might have been something verbal years ago. All I'm saying is that the The shed needs substantial variances. The shed does not have to go there.
Okay, let me ask you that. Even if he moved it back, he would still need a variances.
Yeah, he would need the side
But
setbacks.
how's he gonna get rid of it?
I am sure that the neighbor would allow them to, they have to remove the other shed, they have to go onto the neighbor's property to do that, and that's not really anything to do with us.
So my question is, if he does move it back, are the other owners gonna allow or fight the variances?
They, again, we weigh out the options between the detriment to the nearby owners, to the applicant himself.
Yeah, because if they're okay with it, his 2 feet or whatever would be his issue for another court to decide, as Jeremy explained it. My thought is, if the other landowners are okay, if he slides it off, and they're okay with him getting the variances, then it's really not a lot to ask if nobody's in objection.
I agree. Although the variances are pretty substantial.
Understand.
And it could be relieved by moving the shed someplace else on the property.
True, but that's like my argument is if everybody around him's like, oh, I don't care, then is it substantial? Because
Right.
you're not going against anybody, so it really kind of, it is and it isn't.
Okay.
We had one that objected, one that did not.
You have two that don't object. So Offenbach to the south, and then Kibble to the west.
Okay, so, we had quite a bit of discussion, with that, so we're gonna open up to the public, and,
Yeah,
We-
all right, so, I have no problem with you opening it to the public. I just wanted to address one other point.
Oh, I'm
and for-
sorry.
No, it's
Forgot.
okay, it's okay. I'm trying to open the PDF to specifically show you the language. Mr. Velikat, I can simply send you these documents for whatever reason. They don't want to open on my computer right now. It's saying it could potentially harm my computer. I don't know why. But in any event, I will send this to you. It identifies a few provisions that you should review with your neighbors because it has internally contradictory and conflicting information regarding the longevity and what you can or cannot do, and that will have to be rectified before I could say, yes, this is sufficient for recording.
Gotcha. Excellent.
Okay? So I'll forward those to you via email. You'll address that with your neighbors. And that'll have to be resolved before I could sign off and say, yeah, go ahead and get this signed,
Okay, great, will do.
assuming that they give you the variances.
okay,
Sorry.
that's all right. Public hearing's open. You just come up if you'd state your name and.
Hi.
You're good, you're on.
I'm on, okay.
Yes.
My name is R.G. Bowman. I'm a neighbor of Indian Park. I'm a trustee from Indian Park, and I'm a neighbor and friends to all. But my question is, can you stop calling that a garage if you can't even get a car through that little piece there?
So we're gonna call it an accessory structure because that'll cover just about everything, because it's
Okay.
an accessory to
Yeah,
the house.
Because when she spoke, she said you can't even get a car through in it. And for years, I've been looking at this map saying, how is it called a garage when you can't get anything through? Okay, and just as a point, I don't know if it really matters, but I'm the treasurer for Indian Park as well, and there were 2 other pieces of landlocked property that were discovered very late, and the people who bought other properties around there didn't know it, and they didn't realize that they could be managed in a way like a purchase or a give. So I don't know if that matters. That's.
Well, if there's other landlocked parcels within the community,
Not anymore.
Okay, well, it wouldn't be
No.
relevant necessarily for this board that's considering this application. We're really only considering these particular parcels that are owned by the applicant and the immediately adjacent parcels to it.
But you're saying that that was from day one, that that little triangle there was attached to his property?
What
Is
I'm
that what you're
saying
saying?
is, in looking through the
Yeah.
deed records, the triangular portion has been a part of this larger parcel in each successive deed, at least back to the 1960s. I didn't bother looking any further beyond that, because it's no longer relevant.
I'm a little confused.
Well, the question is, was this particular triangle added to the applicant's lot within the last 10 years? Or has it been a continuous portion of this lot and subject to prior use for the last more than 50 years? So if it has been adjacent to, owned by, and used in whatever capacity by the particular applicant's predecessors in continuity for more than 50 years, then there's sort of a legal presumption that the applicant would have the continued right to continue to use it, whether the neighbors like it or not.
Okay. I'm a friend and a neighbor to Mary Ann Cassini Johnson. And to the best of my knowledge, her mother owned it before her. And since 1947, she thought that that piece of property was hers.
I
prior-
have no idea. I didn't look back to 1947, and if Ms. Johnson would like to secure a title report and present it to the, either this board or court and make whatever arguments she wants to make, she has the right to do that. But it's not my responsibility to research everybody's title to see how far it goes back 100 years. I simply tried to satisfy my legal curiosity as to whether or not this particular section of the property has been in continuous use for more than 20 years in association with the larger parcel, or was it just newly added? Because that would potentially change the legal rights of the current owner.
Okay, I'm only the messenger here.
I understand. I understand. I'm just simply,
Yeah,
pointing
you're-
out.
You're the messenger too.
Yeah.
Okay,
There's only so much I can do.
right, okay. I guess that's all, thank you.
Thank you.
Oh, the other shed is gonna, the one down at the bottom, is that going to be
Removed,
removed?
yes.
Okay.
Point of clarification, are you pointing to the one by the street?
Yes.
Or are you talking about this one?
That one up there.
The one down by the road,
No, no, not, we're talking about the one
this
that's,
one. You're talking about that one, I'm talking about this one.
well, there's two accessory buildings up on the top. The smaller one, lower to the left, that one is to be removed.
That one the applicant has already started working on removing.
Okay, but this one's still,
We haven't discussed that one yet. That needs a variance for the front yard setback.
and
Or,
that's tonight?
I don't know that we're gonna get that far.
Okay.
So I just wanted to note, while we're on this particular matter, Mark, at the last meeting, there was a discussion about, instead of doing a drive-by, that someone was gonna try to actually gain access to the property to look at it. That was actually even reflected in the minutes, and I just wanted to know whether or not anybody here on the board actually had an opportunity to do a site inspection.
I did from the road, and then I did off the Google Maps because I needed to see that's how even though it shows on this map, what it shows is a gravel driveway. to access both of those sheds. So, cause I didn't have to see it, any further. I just, again, I looked at the whole thing on the maps, not just this. So I can't speak for anybody else, but
I was just curious because it was something that was referenced at the
Yes.
last meeting, and I just wanted to make sure that we didn't, that we addressed that particular issue. So does anybody feel that a more formal site visit is necessary? Any members of the board?
Diane knows it well. It's up to you guys if you feel comfortable for what, for what you've seen, then that's fine. Like I said, my visit with the maps,
Does everybody remember? Did you guys see this last month? Okay.
And I have additional photos and video as well.
What I'm referencing is the color photograph that you provided with a picture of the two sheds in the upper triangular area. I just wanted to make sure that the board had an opportunity to see that last time.
So are you still gonna move the large shed backwards to get off the neighbor's property?
My understanding is if that's what's necessary to get the variance, then
We can't give you a
1000%
variance on someone else's property.
She's gonna grant me an easement.
Yeah, but that's not done yet, so we can't.
Correct.
So you're not gonna move it at all at this point?
But no, I got it priced out to move because that was my understanding that needs to happen. I'm trying to sell the small shed and have the movers do everything at once so that I'm not paying them extra to come out multiple times.
Yeah, so, Glenn, I think your question was whether he's gonna move the 12 by 20 shed so that it's no longer encroaching on anybody's property, correct?
That was the question, because last time I thought we're under agreement to move it to the rear and where no variance is required. I thought at the last meeting, we'd said if we moved it to the rear, there would be no variances required. And it looks to me like if you move it to the rear, you could still get 5 feet all the way around it, but maybe I'm wrong.
No, you would not. Yeah, it wouldn't be enough for 5 feet all the way around. Because if this shifts back, this corner's still gonna be pretty close to
Still
this
gonna be
property.
close, okay.
She's fine with it. And that's acknowledged in the first easement agreement that we discussed.
So-
So she's okay with it, but it would still be within that 5 feet.
And
So
how much is
I
on the
have-
other- oh, sorry, how much is on the other side?
That's my question, is if you move it back in an angle, how far will it be from the other property lines?
From this one,
The side yard?
The one that, yes.
definitely not 5 feet, because right now this is less than a foot here. So if you just go straight back, it's still gonna be just a foot or two, probably from.
So right now, that's only a foot or two?
Yeah, at this section here, that's probably about a foot, maybe 2.
Oh, so if you moved it in an angle all the way back, you're still gonna need the variance on that.
That is correct, and that's also why I saw the letter of no objection from Offenbach, because when we move this back, to really clear this and make sure that they're all the way back, we would be pretty close to this line as well.
And those two people are okay with it?
Correct. And just as an additional point, I know I said this last time, Ms. Johnson owns this property here as well as the one across the street. That is where the domicile's at. This lot is vacant with the exception of a shed and a boat, and that's all at the front of the property. This is a very steep hill, and you cannot see the shed from down below during this time of year with all the trees and leaves and everything like that. You can obviously see it during the winter, but you can't even see it right now. So it is not in any way impeding her view, harming her structures, creating any sort of nuisance. It's been there since 2010 without harm or complaint.
you need the, to review the easements.
Already have.
I thought they had to do some more work before they had,
Yeah, so I have reviewed the easements, but there is additional language that would need to be clarified in there with respect to the applicant's ability to continue to maintain the structures as they exist and/or replace them. So there's some conflicting language within the document that needs to be straightened out as to what the applicant's rights would be under the easement agreement before they could be approved.
okay. All right, bring over the other side because we're gonna look at the patio. When I went to the building department, I specifically went to see Stephanie today just to confirm what we had looked at before because she had showed me pictures from year to year to year. The wood deck, when was it built?
I don't know when the wood deck was built. I do have an appraisal document from the previous owner from 2013, which shows that deck there at that time.
Okay.
No, I don't want to speak it any further than that. Like, I just don't know specifically outside of that. I do know at least 2013.
Okay. No. That was one of the things that we had looked up right away, but there wasn't a permit, but she was going through the pictures, and it looked, so how long have you owned the property then?
October
Okay,
of 25.
okay. And is that at the time when they did an abstract and the building department came and said that there wasn't a permit for the deck, or that it was over the property line?
The deck was never an issue with the permits during the municipal title search. That was never the issue. Only after I got the land survey was I made aware that this is over his. So I just proactively reached out to Mr. Berry to get an easement agreement to ensure that I would run into no further problems like we are with everything else.
Okay. So the public hearing is still open. I'd like to, just get those few questions answered in the planning department, and the building department, but you also need, you're gonna have to see, an easement that you're gonna accept before we give a variance.
Well, it's either that or the zoning board could consider the variances and set a condition that the easement agreements be edited to the satisfaction of the town attorney.
Okay. Like I said,
It's up to the ZBA.
I'd like to get just a little bit more information, but I'd also like, you know, we look at what's there, but, like I said, the relocation of that is something that is feasible. I think that we should look at that as that option.
And may I just say, you've seen the property, the topography of the rest of the property. There's nowhere level to put that thing. Like, that size of the 20 by 12.
Just scoot the picture over so we look at the front yard, because we had that issue before. Zoom in on the front shed.
Down here?
Yeah, the one closest to the road that doesn't, and can you just drop it down just a little bit? Okay.
I'll make the motion to leave the public hearing open and continue next month when we have a little bit more information.
I'll second.
Okay, that'd be great. All in favor?
Aye.
Aye.
Any opposed? Motion carried. Okay.
I'll work on editing the easement agreements.
Yeah,
Get you-
I'll send those out to you, and
Yeah.
you can work on that
Okay.
in the meantime.
And once I get those back, then there's also the issue of the tax form approval for the exception.
Yeah, again, I want to advise you to avoid having any of those documents fully signed and executed prior to the granting of the variances, because otherwise it raises other legal questions about whether or not the granting of that easement was even authorized, et cetera. So, I did review the tax form. I can and will work with you with respect to getting the exemption from the transfer tax approved as necessary prior to recording, but I would also advise you not to have the document signed unless and until the ZBA grants your variances.
Okay, that's understood. My understanding before was that I had to have it signed beforehand, but
No,
now-
I
okay.
actually would prefer that you only have drafts prepared that meet the legal requirements, and when you have the variance, then you get those things signed, you know, with the understanding that the neighbors have agreed to this.
Yeah.
Yeah.
Okay. I guess my next question would be simply, if we're pushing this out a whole nother month, I'm trying to move these two sheds at the same time as to not incur additional costs unnecessarily.
So if you're moving that, why do you need the easement?
Meaning if I move it this way,
You
I
need-
still need an easement.
He still needs a side setback.
Right.
Fence, stone wall, stuff like that. So what I'm saying is, can I,
But the easement won't affect this, this board and that shed.
No, the point that I think the applicant's trying to clarify here is he was already working, if I understand correctly, on removing the 10 by 10 shed. And I believe what you're asking the board is how do you coordinate the 12 by 20 shed? And if they're gonna have to be removed, can you do that all at the same time instead of getting one done and then going back and doing the other?
correct, and if that shed has to be moved 4 feet this way or removed entirely, I don't want to have to pay for both. I would just prefer to pay for one or the other. So that's why I was hoping for the determination before committing the dollars to that, so.
You're before the board right now, you know, with a violation. It's in limbo. I can understand that you want to remove that. We know that you're going to remove that. I'd wait another month just to see where we go with it.
Okay.
And because right now, you're not in any, I don't know if the right word is violation, but you have the ability, it's
Limbo makes
before
sense,
us, so.
Any further enforcement of the violation that may have been issued by the building permit is stayed so long as you're before the ZBA with a open and pending application and no determination has been made.
Okay. Great. All right, thank you for your time, y'all. Thank you.
Thank you. Craftify Holdings?
Good evening. Do you all receive the updated plans that we submitted on June 1st? The architectural plans that reflect the discussed glass storefront, sort of, frontage of the building, and also the clarification on our site plan title sheet that clarified what all of the variances that were required were?
Yes.
I can quickly walk through those.
I'm sharing.
We clarified for the building addition that there is a 10.93 foot setback where 50 is required, a side yard setback of 35.25 feet where 50 is required. The building height requirement for, I believe it was non-conforming buildings that require the 4 inches per foot height limit, which puts our maximum height limit at 3.6 feet, whereas we're proposing 25.7 feet. And then we have the ground floor increase of the 64.1% proposed when 15% is allowed. And then we have the change of use from manufacturing to food and drink, which the tables for the two of those are identical in terms of the lot size, lot width, depth, setbacks. All of those things are identical for the two different uses. The only difference is then that the food and drink requires less loading space, which is already an existing non-conforming for manufacturing. And then it requires more parking, which we do have adequate parking from our discussions with the planning board, that we are expanding the lot to include some gravel spaces, which will be good for the highest use points, which will require more parking, that'll be gravel parking areas around. Does that cover everything, Luna?
I have the lot area, so that's
Mm-hmm.
2.2 to 2.8. Step up just so they can hear me. We have the lot area, which is just essentially confirming the existing nonconformity, which is 2 acres to 1.3. As Justin was discussing, that's at the request of the planning board attorney, Mr. Krahulik, since we're changing from manufacturing to eating and drinking.
Similarly, the lot width and depth are the same. That the technical lot width requirement is 200 and lot depth requirement is 200, but the existing non-conforming is 171.6 for the width and 182.5 for the depth, which again are existing non-conformings that are from the manufacturing, and so we're just reiterating that it's the same exact requirement for the food and drink use. We just want to clarify that to make sure that's on the record as far as the change of use goes.
Does anybody have any questions right now before we open it up to the public? Okay.
No.
I guess, one of the things that we were looking at were those numbers on, if I remember correctly, the square footage, which they are showing now at 64.1 minus the 15%, so we have 49.1. But we had to do all of those calculations with the floor area, and
Yes.
you reviewed those and are, what's the word I'm looking for?
I reviewed and revised the comments that were provided to the Zoning Board of Appeals in my comments to identify the specific setback amounts that are being, as recalculated by the applicant on their revised plan, to identify what the requested setbacks are. The applicant just summarized them. I've highlighted them for all of the ZBA members in yellow, highlighting individually within the various different sections of the comments.
The other thing that came up last meeting was the floor area ratio, which we clarified we do not need a variance for. That we are proposing, I think it's 38%, where 40% floor area ratio is allowed, or
And for-
0.38, 0.4.
Yeah, and for the benefit of the ZBA members, in your comments near the bottom of page 2, section 9D, I did update the calculations between the existing and the proposed square footage, total floor area of the building, calculation of floor area ratio of 38.1%, where 40% maximum is permitted, and specifically stated in the comments here that no variance would be necessary under those circumstances.
Okay. So the public hearing was remained open from last time, and so I'm just gonna ask if anybody from the public has any questions or concerns. Okay, so that'll stay open. And, what I'd like to do is to go through, the different variances, individually, unless you don't wanna do the blanket variance with everything in one variance, do you?
That's entirely up to the ZBA. Everybody, I hope, has had an opportunity to review these variances, and I think perhaps, Chairman, you could poll the board to determine whether any of the members of the ZBA believe there's necessity to consider each separately with respect to the particular area variances, also keeping in mind that prior to doing that analysis and/or considering each variance, we do have a few interpretations that need to be finalized that we kind of talked about loosely, but I don't believe we've passed motions on some of those interpretive issues.
Okay, we'll take care of the interpretations first, but as Jeremy said, going forward, unless there's something that you have concerns with in a particular one, I think I'd rather know about that now, and then possibly we could do that blanket variance. So, do we have any comments?
Well, my question would be, what exact variances? Name them all off. Because there's one here that's like, well, we require it because they changed the use. So the lot size.
Right, that's what I'm saying with respect to the interpretations that we
Yes.
really should address first as to whether or not, for example, in their counsel's summary, she identified that, Ms. Cassidy identified that if in fact the ZBA is going to require a front yard setback for the expanded pavilion, even though the pre-existing non-conforming building has a smaller setback than the new expanded pavilion, then the same should apply for the side yard setback for the new covered patio, and they would respectfully request a similar type variance if we're going to require one for the front yard setback for the pavilion extension. So that's something that this board needs to actually pass a resolution on, as to whether or not this board believes that a setback, front yard variance is in fact required. And that's in part an interpretation. Counsel for the applicant provided a legal summary identifying that the council's position for the applicant was that the face of the building nearest the front line of the lot, which constitutes the front yard line of the building projected to the sidelines of the lot, establishes the front yard. And while I don't disagree with council's position on that particular point, I would make a distinction between what constitutes the existing front yard where the building is and what the front yard setback requirement is under the bulk table. I do not see them as being one and the same. Just because the front yard may be smaller, it doesn't mean that the principal building isn't still within the front yard setback and therefore in violation of that setback.
Did we talk about that before?
Yes,
Loosely, but
yes,
there
we
was
did.
no, there was
Okay.
discussion, but there was no resolution on that
Right.
issue.
I think we need a variance because, as we discussed, if you change the angle of the building, it wouldn't continue that line in the end. But because we're following the road, I believe it needs a variance.
I agree.
Do we all agree? Because I'm agreeing too, that it needs a variance. Okay? All right. Now with that, then.
Call for a motion?
we could do that, or interpretation, that we agree that it needs a variance for the motion?
For front yard setback first.
Okay. Okay, I was just looking at the interpretations. We'll do that one first. Okay.
So
So
I
anybody
make,
catch that on the motion?
yeah, I make that motion.
I'll second it.
We have a motion and a second. Do we have any discussion?
For point of clarification, the motion being considered is whether or not a front yard setback is necessary for the pavilion expansion along the front property line along State School Road, despite the fact that the pre-existing non-conforming building is closer to the property line than the newly proposed expansion of that building.
Yes.
Okay, do we have any discussion with that? All in favor?
Aye.
Aye. Can you give an aye?
No.
Okay. 4 ayes, 1 nay.
Okay, so likewise, if we have a 4-to-1 majority requiring a front yard setback variance for the expansion of a pre-existing non-conforming building when the existing building is closer to the front property line than the proposed expansion of that building, then we would likewise, the applicant has requested that this board make a similar determination on the side yard setback where there's supposed to be a covered pavilion that's expanded on a covered patio rather, that comes within 32.6 feet of the side yard, where 50 feet is required, and we need a motion to interpret the side yard setback the same as the front yard setback.
I make that motion.
We have a motion, do we have a second? I'll second it. Do we have any discussion? All in favor?
Aye.
Aye?
Aye.
No.
4 ayes, 1 nay.
Okay.
On interpretations then, on page 3A, does a change of use require an area variance?
So more specifically, as the applicant has presented, the planning board, the applicant is simultaneously before the planning board. They were referred to us by the planning board. And the planning board has advised the applicant that a change of use from manufacturing, which is identified in the use table as use group XX, from manufacturing to eating and drinking establishment, which is also use group XX. Therefore, since it's the same use group, the lot area coverage is exactly the same. The setbacks are exactly the same, regardless of the use or whether or not the use changes. And the question is, if the planning board were to make an interpretation that this would require a change of use from manufacturing to an eating and drinking establishment with the same exact use group, would an area variance for lot area, would a lot area variance be required? Because the current lot is 2.0 acres, the requirement is 2.0 acres, and you have 1.3 acres pre-existing non-conforming. Is that correct?
Yes. So either an interpretation that it's a pre-existing non-conforming and the change doesn't alter that, or an area variance, so essentially the same rationale.
So the question before the board is, since it is pre-existing non-conforming The lot area is not going to change. There's no lot line change proposed here, so the lot area will not change. The lot itself is pre-existing non-conforming, created through subdivision approval by the town board, and reviewed and approved and filed on a subdivision map. Is the applicant required to get a lot area variance by mere change of proposed use from manufacturing to eating and drinking if all of the bulk dimensions are identical?
We'll put that in a motion, and then we'll have some discussion on that. So would anybody like to make that motion? Diane, you're on a roll.
I'm on a roll. I'll make the motion.
Do we have a second?
I'll second.
Okay, now discussion. Oh,
Aaron.
This one just a little bit different because everything seems to be exactly the same. But when it comes to giving a variance, I just think we protect ourselves just a little bit more. What was brought up a couple of times was parking. Warehousing requires a certain amount of parking, and eating and drinking require a different amount of parking on the square footage. That'll be up to the planning board to determine. So for that reason, I feel that we should interpret this, or this interpretation, it requires a variance.
I agree. That's the same thought that I had.
Okay, so we had a motion and a second. Any other further discussion? How do we vote?
Aye.
Aye.
Aye. 5 ayes.
That a variance is in fact required?
Yes.
Yes.
So if a variance is in fact required for this, then that would be a 0.7 acre lot area variance.
Correct. Now we're back to, we've gone through our interpretations, needing variances. Do we want to go through them?
One more variance, the height.
Was there,
Was there a height one or a question about the height?
the height one, from what I remember, was because of the proximity, it was something like 3.9 feet or
The
4.
height,
Three
I think
point-
it's a Scrivener's error in your code, but belt and
Yes.
suspenders, we're gonna ask you for the variance.
Yes.
So it's the 4 inches per foot of
Yes.
setback. And we talked about it at the last meeting, that even a fully complying building.
You
Yes.
couldn't even walk into, yeah.
So I think it's a Scrivener's error, but that's up for Jeremy. I understand he's rewriting your code, so I'll leave that in Jeremy's to-do list. But, so we're just gonna ask the variances.
For the variance,
For
yes.
the record.
And that's, so again, when we look at that, it's keeping that in mind.
Yeah. That you-
Okay. I guess,
So for the benefit of the ZBA members, that's highlighted and identified at the bottom of page 2 in your comments under item number 10, building height. Use group XX is subject to a special height limitation in note 3 in the bulk table, which specifies 4 inches of height per foot of distance to the nearest lot line, or 35 feet, whichever is less. The distance from the pavilion to the front yard lot line is 10.9 feet. Times that by 4, divide it by 12 to get 4 inches per foot, and it results in a 3.63 foot maximum permissible building height without a variance. Therefore, based on the square footage calculations and bulk table that was provided by the applicant, they did do, as Mark had mentioned earlier, an average height calculation, and worked off of that average height calculation to come up with their calculation. They did specifically note on the site plan this special height restriction being 4 inches per foot from the property line, and identifying a 3.63 foot maximum building height within the building height calculation of the proposed pavilion on their revised site plan. So it's all in there for the benefit of the planning board. And doing the calculations, the building height for the pavilion based on the average height is 25.7 feet. Subtract from that 3.63 feet of permissible height, and they require a variance of 22.1 foot building height variance.
So how many variances are we up to now? Now we're up to 8, is it?
Five.
So
In total?
would the zoning board,
More than that.
I was hoping you'd do this part.
would the zoning board like for me to summarize the variances that the applicant is seeking?
Yes,
So that they
please.
can be considered in their entirety, or does the zoning board prefer to exclude any of these and consider them separately?
So, what I was gonna ask, if somebody has a particular issue with one of the variances that might need some further discussion, I would rather do that now as he creates the larger variances together. So as long as you're okay with that? Okay.
I'm okay.
All right. And then we will have discussion, and there'll be, I can already see 2 or 3 conditions on things that we've talked about before. So, with that, yes, it looks like we're gonna go for the approval of all the variances.
Okay, so, one second. Would the board prefer me to summarize all the specific variances and then go through the 5 statutory criteria? Or do you want to do the 5 statutory criteria and then summarize the variances?
Summarize the variances first, please.
Okay, everybody agree with that?
Yes.
Okay, so the variances include a proposed front yard setback from the new pavilion to the front yard line, lot line, 10.9 feet, where 50 feet is required. Proposed side yard setback for the covered patio of 32.6 feet, where 50 feet is required. A proposed side yard setback for both sides of 19.8 feet plus 32.6 feet for the covered patio equals 52.4 feet, where 100 feet is required. An area variance of 49.1% of the floor expansion is required because Town Code 16445B1 limits pre-existing non-conforming expansion to 15%, and doing the calculations presented by the applicant, we have 9,423 square feet of existing floor area, 7,013 feet of new covered outdoor space. We subtract from that 973 square feet of pre-existing covered outdoor space, resulting in 6,040 square feet of new covered outdoor area. We divide 6,040 square feet of new covered outdoor area by the existing square footage of the property, which is 9,423 square feet. That gives us a 64.1% increase in ground floor area, where only 15% is permitted, and therefore an area variance of 49.1% of the floor area expansion is required as a mathematical result. We have a building height for the pavilion, as previously noted, 25.7 feet. Subtract from that 3.63 feet permissible height under the special note in the bulk table, resulting in a 22.1 foot building height variance being required. And lastly, as previously discussed, since a lot area variance was determined to be necessary under these circumstances, a 0.7 acre lot area variance would be necessary because the lot is 2 acres, the lot requirement is 2 acres, whereas the pre-existing non-conforming lot is only 1.3 acres. That's it.
Six variances? Does that sound right? Because I thought you said 5, and that's why I wanted to make sure we're on the same page.
Six.
That may have not included the lot area variance that I didn't think she believed it was necessary.
I lumped the front and side yard on my notes, so.
Okay.
Oh, yeah, I identified 2 separate
Two
side yards,
Yeah,
yes.
that's what I didn't have in my notes.
Okay.
I do know, and I think you've already had a resolution on this,
The
the
two sides are gonna be
landscaping
one
was
or one?
the other one.
Both sides.
And then, again, just, this is confirming the existing, loading bay, there's no change. But again, given the nature of the application, just, that was in our survey, the loading zone.
Right,
What-
Remember, you'd asked us to move it back away.
Right.
We put it on that side, we put it back where it is. Either, we treat it as a pre-existing non-conforming or
No, the loading zone was previously reviewed and approved by the planning board as part of the original subdivision, and therefore, we don't have to reconsider that if you're leaving it where it was previously approved.
if that's your position, I'm totally with
Yes.
that, thank you.
Yep. It was already reviewed and previously approved by the planning board.
Okay, done.
Just a question on the multiple side yards. You have 2 side yards you lumped together. Are they the same exact distance, or are they?
No,
No.
that's why I read them separately. The 2 side yard setbacks are different. So under the code, a 100-foot side yard setback for both sides combined is required, where they only have 52.4 feet. That 52.4 feet is a combination of 19.8 feet for the rear covered patio, and then 32.6 feet is the pre-existing non-conforming, or maybe I have it backwards, sorry. I believe one of them is pre-existing non-conforming out to the parking lot.
So should we do them separate?
No, it's a separate, so under the bulk table, we have a single side yard setback, and you have 32.6 feet where 50 is required where there's a new expansion. And then there's both side yard setback of 19.8 feet, which is pre-existing, and a 32.6 feet where there's a new expansion for the covered patio results in a both side yard setback of 52.4 feet where 100 feet is required under the bulk table. And the only reason we have to do that is because we've determined that the single side yard setback variance would be required, therefore the both side yard setback would be required for the same 32.6 feet. Any other further questions before we consider the 5 statutory criteria?
No.
Okay. In considering the granting of an area variance, the Zoning Board of Appeals is required to consider the 5 statutory criteria. The first being, will an undesirable change be produced in the character of the neighborhood or detriment to nearby properties be created by the granting of the variance requested? The applicant states no, for the reason given that the project proposes an extension of a pre-existing non-conforming side yard setback as set forth in the letter submission. The extension will create a safer and more aesthetically pleasing and cohesive development. Does the board agree with the applicant that an undesirable change will not be produced in the character of the neighborhood or a detriment to nearby properties be created by the granting of the variances requested?
I agree.
Agree.
2, can the benefit the applicant seeks be achieved by some feasible method other than the variance? The applicant states no, and the reason given. After reviewing several proposals with the architect, this is the only feasible development which maintains the natural beauty of the property and provides benefits for the patrons and adjoining properties. Does the board agree with the applicant that the benefit that they seek cannot be achieved by some feasible method other than granting of variances.
Agree.
Agree.
Question 3, is the requested variance substantial? The applicant states no, for the reason the variance is pre-existing and is a side yard setback along a roadway.
Disagree.
Disagree.
Question 4, will the proposed variance have an adverse effect or impact on the physical or environmental conditions in the neighborhood or district? The applicant states no, for the reason given. As set forth in our letter submission, it's the applicant's intent that as part of this expansion, the environmental conditions will be lessened. Does the board agree with the applicant that the proposed variance would have no adverse effect or impact on the physical or environmental conditions in the neighborhood or district?
Agree.
Question number 5, is the alleged difficulty self-created? The applicant states no, and for the reason that the side yard setback was non-conforming when the property was acquired, although it has been expanded slightly, this was not created by the applicant. Does the board agree with the applicant that the alleged difficulty is not self-created?
It is
It's self-created.
Okay, so we've considered the 5 statutory criteria. There was previous discussion that was reflected in the prior minutes, as well as conversations throughout this application regarding potential conditions that the board needs to consider, whether or not any additional conditions to the granting of these variances would need to be considered.
Can you read off what we have listed?
I'm sorry?
Can you read off what we had listed? Or
Would you like me to do that?
just so we all know again, right where we are, we didn't miss anything.
Okay.
Yes, please.
So, we're gonna do these one at a time instead of en masse. So we get a determination as to whether the board feels each specific condition is required and whether each specific condition needs to be modified before determining if it's gonna be required. Fair enough?
Fair.
Okay, condition number 1, that on the pavilion, that the roadside of the pavilion could be enclosed with glass or some other enclosure such that no more than 1/3 of that side of the pavilion along the roadside would be opaque. Is this a condition that the board wants to impose, and does it need to be modified from that?
Want to impose that.
The only other one is,
Never to be added on or enclose the rest of them.
That's a separate one.
Yeah.
I just want to consider these one at a time so that we don't get too complicated with one versus the other.
Okay.
So
So it would be,
we have all 3 of them here.
okay.
So I
This is
agree with
This
that.
is on your page 3 on your notes, item number 13, this is condition A, that the roadside wall of the pavilion adjacent to State School Road could be enclosed with glass or some other substance that would not be opaque, such that no more than 1/3 of that wall would be opaque.
And can we clarify that it's just the portion of it that is closest to the road here, that this portion of it, while not going to be a loading dock, is just, this part will be opaque, but over here we'll have.
Correct.
Correct.
It's just the main wall that is running parallel to State School Road.
Thank you.
But the rest of it is open.
That's a
Correct.
separate issue.
Separate issue.
Correct.
Okay.
And that's reflected in the plans that were sent today?
So then we would need to add to that, as your point, Mark, that not only that the wall that faces State School Road be not more than 1/3 opaque, but that the 2 other adjacent the 2 other walls facing south and west would be open.
Yeah, if that needs to be clarified at all, that's the section parallel to State School Road is 1/3 opaque, 2/3 translucent, and then the portion along State School Road that's not parallel, that's inward a little bit, is the sort of serving area. That's the one other spot that will be sort of closed off so that they can serve food from there. The rest of it is open seating area.
Your call, Mr. Chairman.
You wanted to, I know it's my call, but you wanted to, in reading this off, go through to give a variance just for this one?
No, whether or not conditions would need to be considered before granting any variance.
Yes.
We need to determine whether and to the extent conditions are necessary, and if so, what those conditions would be before the granting of a variance.
Yes.
So, on condition A, the fact that the, as already articulated, I don't want to recite it again, that we would have two open walls facing west and south on the pavilion extending along State School Road, that the north wall would be opaque, and that the east wall immediately adjacent to State School Road would be not more than 1/3 opaque,
Correct.
otherwise translucent of some sort,
Correct.
or open. Do we have a motion?
I make a motion.
Second.
Motion is second. Any further discussion? All in favor?
Aye.
Okay. The second condition that was specifically previously discussed is that the roadside pavilion, the new extension roadside pavilion along State School Road would not be added onto by adding a second story. Any further discussion on that?
What Aaron had said about.
Or closing in the outside, the rest of it at any time.
We already just covered that with
Yeah,
the first
just the
condition.
back, so.
But it was, well, there were two parts, not building up nor.
Or building out,
Or adding on to.
yes.
And I don't know on the adding on to part if it's,
Or would you just say not expanding it at all?
Mr. Chairman, we would, just to remind you, because we're so tight on our FAR, because we're at 38% and our FAR is 40, we would need a variance to do pretty much any addition of anything, because we're right there, we're right under the cap. So that together, and we have no objection to the condition, but that together with your condition should prevent any further adding on.
I know, but except you would come back and ask for a variance.
Yeah, but then you can say, I told you so, Miss Cassidy.
Yeah, I know, I know.
Hey.
I would just rather know.
Do it
that-
now.
So, definitely the adding on to on above, second story, and then, but to say no further expansion. And again, I'm throwing that out there, but if,
Well, this way they wouldn't be able to put like an awning or something on the side, because that would increase the square footage.
yeah,
So that's what I would say. No adding up, no adding out.
no further expansion.
That's basically what I feel.
So, and again, that was the main reason for us to interpret on the, that they needed a variance, because now we have control in the open space, and we also have control in not adding on to the top. So if they didn't need a variance, then they get a building permit for a two-story as opposed to the one. And again, needing that additional space, or that square footage, that would go over the 40%. So, any further? Okay.
I don't know, it just seems to me like we're taking a non-conforming building already and making it more non-conforming. So what's
We
the
are.
difference if it just goes more non-conforming? Because we're going already way out of.
We
realm.
are, and that's why we're saying no. And then it's almost like in a
Well, they can come back again and,
No, they won't be able to.
subdivision, when it goes through and they put on the deeds, no further subdivision, you're done.
Yeah, it's,
Even though things had changed,
not necessarily.
well, it would be a map note. It would basically be a map note saying, no, we gave you this with the contingent that you cannot do anything else.
okay.
I disagree with that part.
Okay, So, did we have a motion?
I'll make a motion.
Second? Any further?
A clarification on the motion,
To not expand, either up
no
or out.
expansion up to a second story on the pavilion or otherwise further expanding the newly covered spaces outdoors?
Yes.
How do you want to articulate the further expansion?
This is for the pavilion.
The pavilion.
For the pavilion only.
Yeah.
Out of the pavilion.
Yeah, no,
The
yes.
rest of it is internal to the site. Again, we would need a variance anyway if that
Right.
were ever happened, but this is applicable to the
Right,
pavilion.
to the pavilion.
Yes.
Okay, thank you.
Does that help you?
Yes.
Okay. We have
That
a
the
motion, second?
roadside, yeah, that the roadside pavilion can never be added onto by adding a second story or otherwise expanding it.
All right, if there's no further discussion, how do we vote?
Aye.
Aye.
No.
5, 4, and 1. Okay?
I said yes.
All right.
But Glenn said no.
Glenn's in there.
The third specific condition that was previously discussed that needs to be determined is that the application is subject to further planning board site plan review and approval regarding parking and other elements not related to area variances to be reviewed and approved by the planning board before the applicant can go to the building department for a building permit.
Before we make a motion, any further discussion? We had talked about that before. It's not really our thing to talk about parking, lighting, all the other things. It's all planning board issues. So we're giving them the variance on the
Strictly the area variances that require those variances so that the planning board can further review the rest of the application.
Okay. So with that said, do we have a motion?
I'll make a motion.
I'll second.
Any further discussion? All in favor?
Aye.
5 ayes.
Okay.
Okay.
You've heard the 5 statutory criteria. We've determined 3 conditions that were previously specified. Are there any other conditions that any board members feel are necessary before considering or voting on this application?
No, you're covered.
Would someone care to make a motion granting or denying the variance as amended?
I'll make a motion to grant as amended.
Do we have a second?
I'll second it.
You got a second? Any further discussion? All in favor?
Aye.
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 Diane, no. 5 ayes. 4 ayes. Diane, no.
All right, that's a majority. You guys will have a determination in approximately a week to 10 days.
I'm gonna close the public hearing, I forgot.
Oh,
Motion to
Yes,
close the public hearing?
Yeah.
we can't take off yet. There's one more item on the agenda. Sorry, I know it's late.
May I?
Yes.
Because you're probably tired.
Am. My brain's fried.
The, I hope I say it right, Sibylla application.
Correct.
What we're happening is we're being nice and allowing somebody the time to get the information that they need to find out from the planning board and to see what variances they need. They might not need any variances. And so they say that they're gonna be here in whatever, and then they ask for another extension. What's happening now is we have people calling because it's on the agenda and they cancel at the last minute and people are making plans on being here and are getting very upset. What I'd like to do, or what I would vote on if we,
So just before you say that, just as a point of clarification for the benefit of the board and the public, what's being requested, we received a request from attorney John Capello, once again, this afternoon, requesting an additional extension of 3 months. The last request was made on, whatever it was a few months ago, requesting an extension to today, June 26, 2026, June 22nd, 2026. We received this afternoon an additional request for a 3-month extension on a ZBA meeting that we have held open, and the applicant has not been here since April 28th, 2025. This is more than a year that the applicant has not appeared to address the board.
Let him reapply.
And the
I don't
technically,
think we should give him
Well,
any more extensions.
hold on, so, okay, that's the question that we need to determine. First and foremost is whether or not the board wants to consider granting any further extensions of time to consider the application before the board.
I'm saying for everybody, I'm pretty sure the answer is no.
Okay. So that being said, since the public hearing has been held open since April 28th of 2025 on the request of the applicant and the consent of this board, does the board wish to continue holding the public hearing open any further beyond this evening?
No.
No.
If we don't, does it deny them automatically, though?
No.
Okay, then no.
Okay. So are you closing the public hearing?
Closing the public hearing.
Okay, so the public hearing is closed. The board now has 62 days to issue a determination on this particular application.
So you need a motion on that?
If you want to make that motion tonight, you may, but if you want to delay making that determination until next month, because it's already after 10:30 at night, we can do that too. We have 62 days from tonight to make a determination one way or the other, and if the board fails to make a determination within those 62 days, then the application is automatically denied.
All right. So we've already determined that we're not giving them an extension.
Of time to keep the
Of
public
time to
hearing,
keep the
to keep the public hearing open, correct?
We've already closed the public hearing,
Yes.
so why can't we make the decision to
Now.
have them reapply when they're ready?
You can't just simply decide you're gonna have them reapply. You would either have to deny their application, and that would result in a denial, and then they would have to readdress it actually as a rehearing, which would require a supermajority vote of the ZBA to even reconsider.
I'll make the motion to deny it if you want.
I second it.
And Jeremy, I understand what you're saying. The truth is, though, that if they went to the planning board and they needed a variance, I am sure we would rehear but before us, we don't even know what variances they even need right now.
Okay.
So I don't have a problem with.
Why don't you leave it on? Leave it on until next, they're not coming.
Well, let's just do it now so Jeremy can get the.
You have a motion and a second. You have to call a vote on whether or not it's gonna be denied, or if you wanna withhold decision.
Can we discuss?
Yes, absolutely.
Right now's discussion.
Right. That's what I'm engaging in.
What's your thoughts, Bill?
Sorry.
No, so if they have 62 days and they haven't
Right.
shown up for 13 meetings, what's another 2 meetings?
Really isn't anything.
We could do, we could do this again, we could knock them down now or give them one more meeting. Do they come off the agenda when the public hearing closes?
They do, because there's no public hearing.
Right, so if you do that, then we're not gonna cause that confusion with the
Yeah.
public,
Correct,
but still give them their 62 days.
correct.
To do what?
And the board could consider this and deliberate either next month or the following month, for that matter, if the board so chooses to do so.
So I want a shorter agenda too, but, you know, if they're
No, I'm
entitled to
not
62
looking at it.
days,
Give them the 62 days.
that's how I feel.
Okay, we have a motion on the floor in a second, so we just can't get rid of that.
Well, we can withdraw it if the intention is to withdraw it. But I think we should just,
I think you're just accepting the inevitable.
Well, are we withdrawing it, or are we voting?
Show up anyway.
We're gonna vote on it right now, I think we're
Okay,
gonna find
then
out.
call for a
So
vote.
for discussion, so the motion was to
Deny the application.
deny the application. Okay. All in favor?
Aye.
Aye.
Done.
You got 3 ayes, I don't know how the other 2 went.
Nay.
Uh,
Can I make a motion?
To adjourn?
But-
Oh,
well,
wait,
To
no, you
adjourn?
got minutes to approve.
Yeah, that's what I was just gonna say, which I
Yep.
tried to do in the beginning and forgot.
I make a motion to approve the minutes.
We have 2 sets of minutes. The April 27th and the May 26th minutes have both been circulated.
Yes, I make a motion that we approve them as presented.
Second.
All in favor?
Aye.
Motion to adjourn.
A motion to adjourn?
Second.
We're out of here.
Good night.
They were denied?
No, afterwards, sure.
Oh, my God, I can feel my feet.
Jeremy was long-winded.
Well, you're used to sitting that long at your jobs.